The public. Today, on January 14th, 2025, the advisory group of experts has gathered in full force and effect to interview the candidate for the position of the judge of the Constitutional Court of Ukraine, Oleksandr Vodiannikov. In particular, all 6 members of the AGE are present. AGE Secretary Maureen O'Connor, AGE member Hanna Suhotska, AGE members Alesh Zalar, Yaroslav Romaniuk, and Vasil Shakun, as well as myself, the AGE chair, Oksana Vasilchenko. Also, present during the interview are 5 deputy members of the AGE: Thomas Griffith, Vitaly Machinchuk, Volodymyr Kuzmenko, Marek Zubik, and Richard Barrett. I would like to note that we are working in a shelter, so in case of an air raid, the interviews will continue without interruption. I would also like to remind you that the interview is being recorded and will be broadcast live on the AGE's resources and the CCU website. Therefore, I would like to draw the attention of the AGE members and the candidate to limit the use of sensitive data and restricted information during the live broadcast. If it is necessary to discuss such issues, the AGE will limit the broadcast for this time. We are ready to begin, so I will now hand the floor over to AGE Secretary Maureen O'Connor. Please, Maureen.
Welcome, dear colleagues and everyone who is watching. As Ms. Vasilchenko has already said, the advisory group of experts will now conduct an interview with the candidate Oleksandr Vodiannikov. I would like to remind you that the opportunity for an interview is a mandatory stage of the assessment of candidates as part of the evaluation of their compliance with the criterion of high moral qualities. Each interview will take approximately 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask all candidates to be concise, to answer the questions clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a short closing statement of up to 5 minutes. I would also like to note that while processing the materials on candidate Vodiannikov, the AGE sent him questions for written explanations so the candidate had the opportunity to prepare and to provide answers. So now that we have with us the candidate for the position of Judge of the Constitutional Court of Ukraine, the candidate was admitted to the competitive selection by both the Verkhovna Rada Committee and the Competition Commission under the President of Ukraine. Mr. Vodiannikov is a senior project officer of the Organization for Security and Cooperation in Europe's support program for Ukraine. He has published more than 50 scientific papers both in Ukrainian, and abroad in English. He has been a member of the European Society of International Law since 2007, the American Society of International Law since 2007, the International Society of Public Law, ICONS-S since 2017, and the International Political Science Association since 2019. In 2002, he received his Master's of Laws in Comparative Constitutional Law from the Central European University, Budapest. In 2016, he defended his dissertation on the principle of tax non-discrimination in WTO and EU law, a comparative analysis at the V.M. Koretsky Institute of State and Law of National Academy of Sciences of Ukraine. In addition, I would like to remind you that the candidate has already taken part in a competitive selection last year and was interviewed by the advisory group of experts. Mr. Vodiannikov, if you would like to add anything to your presentation, you may do so now within 2 to 3 minutes.
Thank you, Maureen, for fabulous presentation. Nothing to add.
All right, then we will begin with the questions.
Олександр Юрійович, я розпочинаю, якщо ви дозволите.
Alexander, allow me to begin. According to the information on the register of court decision, Solominsky Court of Kiev is considering the claim to you and your wife regarding recovering the debt. Could you please comment on this lawsuit? Thank you, Vasily Ivanovich. And first of all, I would like to express gratitude to AG for discovering this lawsuit. Once I learned about this, I sent the request to the court regarding this lawsuit, and I have received the information. This situation developed in the beginning of full-scale invasion when one of the communal utility companies had recalculated the bills. Therefore, they have recalculated our bills to a quite a significant sum. As a result, I requested the consideration of my claim, and once the full-scale invasion started, the utility company brought a civil case to the court, and the civil case went under consideration by the Solominsky District Court. What is the sum of the debt? According to the documents, the sum is 180,000 hryvnias, and I have a counterclaim regarding the 2/3 of the sum. According to the lawsuit, the sum is 180,000 hryvnias. Yes, it's possible. So, do you know the sum exactly? It is quite an interesting matter because I do ask the Solominsky District Court to clarify the sum. Do you want us to clarify it? No, I'm asking the Solominsky District Court of Kiev to clarify the sum. What is the period? What period did this debt accrue? According to the materials of the civil case, it is quite unclear what kind of period is in question. However, once we clarified the situation, there is definitely data regarding 2022 and 2023. What about 2024? I do not have any debt in 2024. So you started paying the bills. I did pay them before that. When did you discover the information about this debt? Do you mean when I received the information on recalculation? So when did you become aware? In 2021. And you didn't do anything about this. I didn't do anything. However, I did send my request according to the administration procedures to the utility company. So I requested clarification from them. Why did I do this? I do believe that the recalculations were not conducted in a proper way. Secondly, I do have a certain legal strategy here, since this situation is relevant not only for me, but also for the majority of people living in Kiev. So I did analyze the practice of the district court, and I did provide this analysis to the materials of the lawsuit, and I believe that this will make the district court to adopt the practice that I presented. As you know, a utility company typically informs the users using certain communication channels about any debts. Did you receive any paper bills, any notifications regarding the debt, any requests to pay the debt? Yes, I did receive them. However, this document can be used as the reason to bring a civil case to the court. And I do know that this document is also available for the AG. this was the reason for the utility company to bring a civil case to the court, and this was the chance for me to stand my ground and to prove my interest. So, what was the reason for you not paying the bills? Did you not have sufficient funds? Did you have any proven communication in the chats or paper communication? Yes, I did provide this as the materials for the advisory expert group, and I also provided these materials to the Solomensky District Court as well as to the utility company. Therefore, you do not deny the fact of the debt. No, I do not deny that. From 2018 to 2024, not 2018. In the materials of the lawsuit, they state 2021. If we speak about the materials of the lawsuit, the period is 2018 to 2024. I understand they generated the civil case at the moment when the utility company came into power of the responsibilities. So this was 2018. However, before 2021, I did not have any debt over the period 2018-2021. Alexander, so here we're speaking about you not paying the debt that you acknowledge as the debt. The matter is that even the recalculations that were made, they were conducted based on incorrect data on the square meters of the apartment. That is why I'm requesting another recalculation so that it reflects the actual data of my property. In this case, you can sign a contract with the utility company regarding the restructuring of the debt. I could do this. However, if it was the debt for the utility services that we did receive, I would do this. However, since the recalculations took place in 2021 and they were conducted in an improper way, the utility company did not agree to clarify these recalculations. Secondly, as far as the communication with the utility company is concerned, I'm not sure why, but this utility company uses the data which is not true. Their predecessor provided them with the correct data on the real estate properties. However, they do not use the adequate data for a certain reason. That is why I'm also asking the Solomensky District Court, I'm sorry, Alexander Yurievich, we are not the Solomensky District Court. We're not considering your civil case, and we are not quite interested in the sum of the debt. We are interested in your behavior in this situation because it certainly affects your authority and the opportunity for you to become the judge. It is hard to imagine that the candidate for the position of the Constitutional Court judge does not pay his bills, tens thousands of hryvnias of utility bills. How can we explain this to the society? Vasily Ivanovich, first of all, this sum was calculated in an improper way that is now under the consideration by the district court. I do not deny the debt. I'm only asking the court, within considering this civil case, to define a proper sum of the debt.
I am convinced that the Ukrainian court will make the fair and legal decision. And before that, I can only comment as a litigant. I see. Which steps are you taking now to repay the debt and avoid similar situations in the future? As this it definitely does affect your authority, your moral qualities, your moral status in the society, and the way the society, the outside observers are going to evaluate it. You have to think how to tackle this. I understand your question. Thank you for the question. Indeed, those undisputable things are taking place because I am paying bills. On the other hand, there is the proceeding, the court proceeding, and I'm even happy at this because this enables me to regulate relations with the utility company and to bring it in order. And my last question is, you mentioned the information you have provided us, the information that you have published up to 50 scientific papers. Could you please tell us who gave this evaluation that all these 50 papers, all these 50 publications, that they are scientific papers? Thank you for your question. Well, first of all, great part of them were published in the journals of category A or B, Ukrainian publications. Second, many of the publications are followed by the recommendations of the corresponding scientific institutions, especially of the Academy of the Law Sciences. So, if there are the recommendation of the scientific council for the publication, then it is recognized as the scientific paper. As for my foreign publications, I don't know the order or procedure defined abroad, but I can assume that they also have the publications in the law, journals publications that are recognized as the scientific ones. Thank you. That's all from me. Mr. Alish?
Mr. Vodiannikov, morning.
Good morning.
I saw from your CV that in the year 2016, you defended the dissertation concerning the principle of tax non-discrimination in the WTO and European Union law. So obviously, you have quite a good legal knowledge in tax law. Am I correct?
Yes, in international tax law, and especially in the area of EU and WTO.
Yes, and that's exactly the point for my question to you. And it relates to the taxation of your income you earned during your work at the OSCE. You have informed the advisory group of experts that between 2011 and 2015, you failed to declare income received from an international organization, and you did not pay the relevant taxes. How can you explain this?
Thank you, Alish, for this question, because it relates a very sensitive issue of relations between the international organization, the OSCE, and Ukraine. As I was explained in writing to the AGE, the tax issue remains at the table of negotiations under Article 8 of the Memorandum of Understanding between Ukraine and the OSCE. that have been suspended for since 2022 due to the war, but it is not finished and will be resumed after the end of the war. As concerns the very essence of the dispute, according to various documents that I referred in my written statement to the age, the participating states committed themselves, and including Ukraine, to provide tax exemptions and tax immunities for the OEC and its staff throughout the OEC area. That was also reiterated in 1994 during the Budapest summit attended by the President of Ukraine. The Memorandum of Understanding was conceived to be the instrument that endorses this specific tax exemption regime for the OEC staff in Ukraine because of the international law principles with respect to international civil service that relates to the mandatory exemption of all staff. However, as appeared during 2012, I think, I can't recall correctly the year, the position of the Ukrainian side differs from the interpretation adhered by the OEC, who considered that the memorandum provides a sufficient basis for tax exemption. Therefore, we as OEC employees were informed that we are exempt with respect to salaries paid in Ukraine. Then the consultations on the Article 8 of the memorandum commenced, and the position for a certain period of time was that we are to adhere to the general position of the OEC, that the staff is exempt from taxation, and as I found in writing, there was some changes in the position that allowed to staff to take a personal decision. It is not legal, it is more or less moral decision whether to pay taxes or wait for the dispute to be settled as per the international instrument in question. I myself take a decision to pay, though it doesn't mean that I consider it's lawful under the international law that my income is taxable in Ukraine, as this income originates from an international organization, which is ipso jure should be exempt from national taxation. Because agree, Aleš, if, for example, participating states is paying a defined amount of contribution to the organization and then offsets some of this sums paid to the general budget of the organization by taxing staff of this international organization, it produces a question of bona fide behavior, compliance with the international commitments of such state. Therefore, to sum up, when the attitude of international organization to the question and the attitude and the policy towards its staff changed, I take a decision to pay taxes. However, these payments still will be part of the negotiations with the Ukrainian side and the applicable international instrument.
Well, thank you for this extensive explanation. You know probably the applicable Ukrainian tax law.
Yes.
Are you aware of the clauses 162, paragraph 1 of the code, which was amended January 1st, 2011, that the payers of personal income tax are in particular resident individuals who receive income from both sources of their origin in Ukraine and foreign income.
Yes.
So that's the applicable Ukrainian law. And do you think that the national legislation still provides an opportunity in the period from 2011 to 2015 not to declare so-called foreign income and not to pay the relevant taxes?
Thank you, Alash. But we have also Article 3 of the Tax Code of Ukraine that provides for if an international treaty provides different rules than those envisaged in the code, then the rules of the international treaty should prevail.
Of course, but you don't have any such applicable international treaty yet.
We have.
It's a matter of negotiations. It's the only memorandum of understanding which you refer to. And the memorandum deals with certain specific issues, such, for example, immunity from civil and administrative liability, but not the tax exemption. So did the agreement which you concluded with the international organization provide for specific taxation of your income?
Thank you, Alex, for your question. That was specifically the position of Ukrainian MFA. However, there is an international agreement. The memorandum I referred to was ratified by the Verkhovna Rada, that is the Parliament of Ukraine, under the applicable law and international treaties in the year 2000. Therefore, there is an international treaty. Second, the treaty provides in paragraph 2 of Article 6, indeed, that the regime applicable to the employees here in Ukraine should be that of the Vienna Convention on diplomatic relations. However, Vienna Convention of Diplomatic Relations is not very apt in terms of full applicability towards international organizations, because there is no such things as reciprocity, there is no such things as mutual recognition, so on and so forth. Therefore,
my question was different. I asked you whether the agreement you concluded as individual with the international organization provide for specific taxation of your income.
No.
In your opinion, how can an outside observer perceive this situation in which you received the labor income from an international organization that was not declared either in Ukraine or abroad?
Well, as concerns abroad, there is no such obligation. Moreover, headquarters agreement with Austria, where my employer resides, provides for the sweeping tax exemptions. Second, as concerns third or outside party dealing with the issue, the question would more appropriate to raise why I pay taxes, because being an international public servant, under the general principles of international law, I should be exempt from taxation just for the very fundamental issues, fundamental principles of international law applicable to international organizations.
Thank you for your opinion. I have no further questions.
May I ask you the question? If we understood you correctly, so you have the debt for the services of the heating for the utility company, because you think that these services were calculated in the wrong way because they didn't define correctly your heating area. Yes, and also because of the adjustment of that recalculation, not only based on the correct size of the heated area. But nevertheless, I would like to draw your attention that the significant amount, which is almost 100,000 hryvnias, 99,000 hryvnias, that is the debt for the transportation of the heating to your apartment, transportation that is not dependent upon the heated area. Then the same refers to the hot water supply services. And then the subscription services for heat energy supply and the hot water supply, these amounts, they are not dependent. Well, I have no debts on these categories that you have just listed. But according to the materials of the lawsuit, yes, but the court has all the corroborating documents that it is nothing like that. Okay, next question then. You have explained that you didn't even know about the proceeding and that you only learned about this from the communication with the ADG. and then you went to the court, you got all necessary documents, yes. The proceeding in the case was initiated on the 5th of June, and then the address where you have been registered, the court has sent you the copy of the lawsuit and all other documents, and up until December, so during 6 months, somehow you didn't get these documents, and you didn't return to the court. Are you not residing in that address where you are registered? Thank you, Alexander Mikhailovich. I don't know why I didn't get this correspondence, because when I referred to the court, they gave me these documents. Maybe there were some mistakes about the address where the plaintiff was submitting. So the court sent these documents to the place of your registration where you reside, right? The place which was specified by the plaintiff. That's where they have sent it to. In the ruling of the court, as of the 5th of December 2024, it clearly says that it was sent in accordance to the place of registration, where as of the 4th of February up until 2014, you are registered. I cannot explain why I didn't get any notifications, but do you live in that apartment? Yes, I do. I see. Thank you.
Proceed.
Дякую. Добрий день, Олександр Юрійович.
Thank you. Good day. I would like to continue the pool of questions. As for, in regard to your debt, you have explained that 2/3 of the debt you do not recognize, you do not admit, and it looks like 1/3 you do. And it was mentioned that it was as of the 2017 up until 2021. Yes, in your opinion? No, as of no debts I had from 2017 until 2021. Okay, my question is, I will pose it a different question. You said 1/3 you admit. So for which period of time do you think this debt has been accumulated? 2022, 2023. So this means that in 2022, 2023, you didn't pay, even though you knew you had to pay. I could say so. I am convinced that you are professionally prepared person. You know the legislation very well. You know that we are on which stage we are of evaluating integrity. Then maybe after you got the information from the advisory group of experts, maybe you should have paid it at least partially. I will explain why this debt occurred. Because I went to check in the system of payments. I checked the system of payments, and I found that in 2023 there were at least three payments that were on hold. Because I decided to pay my debts for 2022, but the system somehow didn't consider this. I guess this was my fault that I didn't pay attention to this, and I'm not denying this. So I can't say that I did something intentionally, that I got confused intentionally. No. As for the dispute regulation, I think that the debt that I admit I pay it, but big part of the amount, the remaining amount, is something that I am looking forward to the decision of the court to regulate it. I didn't get my answer to the question that I asked. Then I will give you another question. In accordance with the civil procedural law, the person can refer to the court in order to appeal the right that has been violated. After you found out that 2/3 of the accrued amount is not real, then did you file the lawsuit to the court? I filed the claim to the state standard of consumption, but they are not going to withdraw this amount. Yes, but they can verify the actions of the utility company. That's one. And second, according to the position of the Supreme Court, the bill itself doesn't serve the ground for me to file the claim, but each of
I'm not speaking about your bills. I'm saying that if you know that something was calculated not in an improper way, you should take certain measures and steps to show both the advisory expert group and the society that you do not have any debt. Yes, I did provide all information to the AG. You did not bring a case to the court. No, I did not, but I did bring the case to other institutions who could protect me as the consumer. Thank you, dear colleagues. Any other questions? No other questions. Please, Oleksandr Yurievich, you can now make a short closing statement, up to 5 minutes, and we will conclude the interview. Thank you. Thank you, dear colleagues. First of all, I would like to express gratitude for this opportunity to meet with you and for your immense work to create an independent and democratic constitutional court in Ukraine. One more thing that I would like to mention, I would like to thank the Secretariat that conducts extremely important and detailed work at the high level methodology to discover all aspects of activities of the candidates. It is an immense work and it is a unique work. So I would like to thank the Secretariat for this. However, my short closing statement does have certain functional limitations and certain concepts which I would like to deviate from. Dear colleagues, we are now in this very sensitive situation for the constitutional law of Ukraine. In just a couple of days, the Constitutional Court will lose its quorum, and there will be only the format of a Senate for the Constitutional Court. It's neither good or bad. This is just the reality that we face right now. At the same time, AG has developed a vast experience and practice, a very interesting experience. There are certain strong points and some weak points to this experience, and I believe that it is time to invite the AG to certain reflections, to the reflections on this experience, to the reflections on what went well and what didn't go so well. Why am I saying this? Because two competitions did not lead to any result. And I believe that it would be also helpful for the society, for the AG, and for potential candidates to use this unique experience as a topic for the dialogue. I do understand that you now have two competitions and you have another competition coming up. However, I do believe that it would be extremely useful for all of us, for the society, as well as for the AGE, to define certain format of the dialogue, taking into account all limitations, because the tool that you are representing can be multiplied and scaled to other spheres as well, and could make it more efficient. Thank you for your attention. Thank you, Oleksandr. Thank you for your opinion. We do consider the interview as the dialogue, and I do believe that you can support us in this opinion. So thank you very much for your opinion. We are in constant touch with the society as well, and we listen closely to the opinions of the society as well as other institutions. Thank you for the provided answers, and Dear colleagues and the public, I hereby declare the interview of the advisory group of experts with candidate Oleksandr Vodiannikov to be completed.